1.25 lakh crore rupees and 17,000 crore rupees. These are two big numbers, and that's how much the Enforcement Directorate has collected from seizures and distributed till now. Let me repeat that: 1,25,000 crore collected and 17,000 crore distributed. And that's not all. In his exclusive interview with the India Today group, Prime Minister Narendra Modi has said that there could be a lot more that will be given away to the poor. And the plan is to utilize the funds, the assets that have been seized for uplifting India's poor. This is what Prime Minister Modi has said in his interview to the India Today group. Let's take a quick listen in.
दो प्रकार के भ्रष्टाचार है। एक जो बड़े बड़े कारोबार में करते हैं, जिसमें लेने वाला भी कुछ बताता नहीं, देने वाला भी नहीं बताता है, ये मुसीबत है। लेकिन ज्यादातर निर्दोष लोग हैं। जैसे बंगाल में शिक्षकों की भर्ती में पैसे गए, तो पता है कि भाई इस आदमी को नौकरी मिली, उसके पास सर्टिफिकेट वगैरह कुछ नहीं है, और उसने बेचारे ने यहाँ से कर्ज लिया या अपनी जमीन गिरवी रखी या घर गिरवी रखा और उसमें से इतना पैसा दिया, तो ट्रेल है। तो अभी हमने काफी पैसे जब्त किए हैं। टोटल प्रॉपर्टी को हमने 1.25 लाख करोड़ की जब्त की है जी, बहुत बड़ी अमाउंट।
1.25 लाख करोड़,
1.25 लाख करोड़ रुपया। तो मैं इस पैसों को उनको, अब जैसे केरल में साहब कम्युनिस्ट पार्टी एक ऐसा रैकेट चलाती है जी, ये बड़े ईमानदारी का ठेका लेकर के घूम रहे, कोऑपरेटिव नेटवर्क। कोऑपरेटिव में गरीबों के पैसे, ज्यादातर नौकरी पेशे वालों के पैसे हैं, और आदमी फिक्स डिपॉजिट में पैसे देता है, रखता है भाई कि बेटी बड़ी होगी तो शादी के लिए काम आएंगे, बेटा बड़ा होगा एक कमरा बड़ा, ऐसे ऐसे लोग होते हैं जी। इन्होंने क्या किया, इन पैसों को अपने निजी बिजनेस पार्टनरशिप के नाम पर बांट दिए और हजारों करोड़ का घपला उन्होंने किया है बैंकों में, कोऑपरेटिव बैंकों में। आपके लिए जैसे वो केरल फाइल को लेकर के तो आप लोग डरते हैं, लेकिन इसमें काम कर सकते हैं साहब। अब उसमें ट्रेल है कि पैसा इसने रखा और इसका डूबा। अब हम प्रॉपर्टी जब्त कर गए हैं। मैं चाहता हूं कि मैं उस प्रॉपर्टी से कैश है, कैश से, और जो संपत्ति है उसको ऑक्शन करके वो पैसे मैं कैसे लौटाऊं। अब तक मैं 17,000 करोड़ रुपए लौटा चुका हूं। 17,000 करोड़ रुपीस जो जिसका ट्रेल मिला। अब लालू जी ने, रेलवे मिनिस्टर थे साहब, गरीब लोगों को जॉब देने के बदले में जमीन लिखवा ली है, तो ट्रेल मिल रहा है। अब वो बेचारा डर के मारे एफिडेविट देने को तैयार नहीं है, लेकिन ट्रेल मिल रहा है कि ये इसकी जमीन गई, इस तारीख को गई, इस तारीख को नौकरी मिली। अब हमने जब्त किया है, हम उसका ऑक्शन करके उस गरीब को जमीन वापस करने के लिए मैं सोच रहा हूं। तो मैं दिमाग काफी लगा रहा हूं इसमें, क्योंकि ये मेरा मुझे मन से फील हो रहा है कि ये गरीबों का पैसा है, ये लोगों ने अपनी पद का दुरुपयोग करके लूटा है जी, इनको मिलना चाहिए वापस।
कानूनी बदलाव करने पड़ेंगे।
कानूनी बदलाव करना पड़ेगा तो वो करूंगा मैं। अभी सब मैंने लीगल टीम की मदद ले रहा हूं मैं, क्योंकि जुडिशरी के लोगों से मैंने कहा भाई कुछ रास्ता बताओ, मुझे इन रुपये पड़े रखने से क्या मतलब है मेरा।
Very significant words from the Prime Minister explaining in detail a plan that seems to have been in works for quite some time now, because the Prime Minister said that he's consulting legal experts, taking a view on how it is to be done, and also putting out that number of 17,000 crore out of 1,25,000 crore that has been seized. And joining me now on the significance of what the Prime Minister has said and what can be expected, what kind of legal framework is likely to take forward the plan that the Prime Minister said of paise lautane ka, is one of the most foremost well-known lawyers on the subject of PMLA, among others, Vikas Pahwa, senior advocate at the Supreme Court. Vikas, welcome to Business Today Television. Thank you very much for joining us. You heard the Prime Minister. We've culled out that a very significant portion from a very long, very hard-hitting, very detailed interview that the Prime Minister has given. I want to begin by asking you to explain to our viewers what is the procedure that is available under law for the seizure of assets, which could be assets, properties, as well as cash, and how are those proceeds seized and then distributed going forward? If you could start by explaining first the procedure that is available under the existing law.
Yes, this money laundering is a new act, as we all know, and nowadays with, a lot of economic offences which are being committed, so Enforcement Directorate kicks in whenever there is an offence which is committed, which is a scheduled offence. So this act has various offences which are mentioned in the schedule, like cases like Prevention of Corruption Act, cheating, narcotics, and the cases like that. So the Enforcement Directorate has the power to attach the property, which according to them is purchased from proceeds of crime. So proceeds of crime is proceeds which are generated after committing an offence. So whenever they have reasonable ground to believe that this property is attached or linked with the proceeds of crime, they can attach it. But this is only a provisional attachment. This provisional attachment has to be confirmed by an adjudicating authority. So this is all, in a very temporary manner, because the entire act is divided into two parts. One is the attachment of property, which ultimately can be confiscated by the central government, and second is the prosecution. So both of them are interlinked. So provisional attachment confirmed by adjudicating authority for a limited period of time, say about 180 days, or during the pendency of the trial. So the moment trial is concluded and the accused is convicted, the property can be assumed by the central government. Right? So both of them go hand in hand. So the moment charge is proved, accused is convicted, the property goes to the central government. So what the Honorable Prime Minister says, that whenever they attach a property and the trial is concluded and accused is found guilty, the property comes to the central government. Central government has a discretion to distribute it to the way they want to. But there is one problem here. The problem is that in every crime there is an aggrieved party. So the act, Money Laundering Act, contemplates a situation and also casts an obligation on the court to see that the aggrieved party is also compensated. So if you have seen the speech, the Honorable Prime Minister talks about the innocent people like teachers who have been, cheated in that crime of Prevention of Corruption Act. So there the teachers who have actually been the victim of the crime can be compensated by the same money. So there are checks and balances, there are provisions in the Act. The only difficulty is you have to wait till the trial is not concluded. And if the trial results into acquittal, then of course the money has to be released. Then property has to go back to the original owner. So these are, some of the provisions which we have in the Act. The following, or the procedure, which is a bit lengthy in this case, has to be followed, and only then the property can be distributed.
Before I move on, I just want to bring up some data that is of interest. Although viewers, it dates back to the 31st of January 2023. The number of ECIRs, that is the PMLA terminology, FIR word is not used as far as Enforcement Directorate action is concerned. 5,906 till the 31st of January 2023. That number would have gone up in the months since then, and the number of trials that have resulted in conviction, this data as per the ED website is 24. The amount of money where provisional assessment or attachment orders have been issued was calculated at 1,15,315 crore at that date. The confiscations under section 8(5) of PMLA were just about 36.23 crore. The reason I read out these numbers, viewers, is for you to understand the overall dynamics and the numbers, and the number obviously of 1,25,000 crore that the Prime Minister gave, and 17,000 that has been returned in some ways. Because from your own understanding, and I know you may not be able to go into very detailed specifics, where would this 17,000 crore have been given? Is it obviously money and assets that have been given back after the conclusion of the trial? Anything that you can share on this with our viewers?
Yeah, actually, Money Laundering Act has two stages where the money can be returned. First is when the charges are framed. That means the trial is progressing. So at the stage when the trial is progressing, there is a provision which can be invoked by the court and the money can be returned to the person who are affected. But the final conclusion, the final transfer of money or the property has to be when the trial is concluded. So I'm sure the numbers which are given, because your data probably is an old data of January 2023. We are now in 2024. So during this interregnum, I presume that the trial must have been concluded, because the distribution of money can only be when the trial is concluded. So distribution of money can only happen when the trial concluded. And if we see the data, because the website of ED does not give the latest data, but the moment we are able to acquire the latest data, we'll be able to find out whether the money was paid during the trial or after the conclusion of the trial.
Absolutely. Because the Prime Minister also said that if legal changes have to be made, and I'm citing the English transcript, if legal changes have to be made, I will do it. I am taking the help of the legal team. I have also asked the judiciary to tell me a way. He then goes on to say what's the use of this money. Now, given what the Prime Minister is saying, and obviously this is not in public domain, the kind of consultation that is happening, what is being alluded to here? Is the Prime Minister referring to perhaps delinking the trial and the return of confiscated assets and cash? What could be possibly under consideration?
I'll tell you that. Look, we all know that there are three new acts, three new major acts which have been passed by the Parliament, and they will be applied from 1st of July 2024. And I was reading the new act and I found there is a provision, section 107, subsection 6 of BNSS, the new CRPC which is coming. There is a provision of attachment of property in all cases. You'll be surprised that it is not confined only in ED cases. So probably the Honorable Prime Minister is indicating to the new law, which is now coming from 1st of July, which has a provision of attachment of property, confiscation of property during the trial, and also distribution. So all three things which are in the Money Laundering Act, subject to the conclusion of trial. In the new act, there is a provision that if the judge is satisfied and prima facie the judge has a view, and also the material to show that there are reasonable ground to believe that the person is guilty of an offence, then the property can be given to the aggrieved party. I think probably the Honourable Prime Minister is hinting to the new provision which will be invoked in July 2024.
Okay, but beyond this, is there any possibility under the rubric of overall laws and the manner in which our courts have interpreted and defined them, that you could completely say that if there is a trial that is underway, pendency of that trial, the money will go back on a provisional basis to those who may have been affected? Because the word of distribution that comes up, I'm trying to understand, the money obviously can only go to the source where it originated from. How would it be distributed across other set of people?
I think you're right, because still the trial is not concluded and the accused is not found guilty, and it is not proved during the course of trial, which is beyond reasonable doubt, that he has misappropriated the money or there is a money laundering. The transfer of property during the pendency of the trial will be a very risky proposition, because if the accused is found not guilty or acquitted, it will be very difficult to retrieve the property from the aggrieved party. That is why, while the PMLA was framed, they are very conscious of the fact that there is a provision of attachment, there is a provision of confiscation. They have kept it parallelly to the conclusion of the trial. That if the trial is concluded, only then you can, confiscate and then give it to an aggrieved party. But I agree with you. I think this is a grey area which probably, when the new act comes, the constitutional validity of some of the provision will have to be tested in the court of law. Because handing over property to an aggrieved party in the midst of a trial will be a very risky proposition.
One more point, at least for my understanding as far as the grey area is concerned. So if a trial is concluded and if the money has been confiscated, and in some ways we have seen that when it comes to illegal cash, there is no claimant also. That money possibly goes to the Consolidated Fund of India. That can be distributed clearly. There is no bar in that. Is my understanding on the right track, Vikas?
You're right, you're right. There are many cases we are doing ourselves where there is a trap. And in that trap, some money, is recovered from the public servant or a private party. So when the trial takes place, the public servant says it is not my money, although he is part of the transaction. Private party says this is not my money because they have to take a stand during the course of trial. And even in the end, when the accused are convicted, nobody takes the ownership of that cash. You're absolutely right. That cash in any case goes to the central government. It has to go to that fund. But those are very limited cases. In money laundering, majority of assets which are attached are the assets which belong to someone. Money laundering is you generate some funds and then launder it. That is, untainted property is being converted into tainted property. So it may be, some kind of a business building, or it may be a house, it may be bonds, it may be shares. When you legitimize a tainted money into untainted money, that process is called money laundering. So in money laundering, there has to be an asset, but the cash is very limited. Of course, cash is recovered in many cases, but it's very limited. Majority of them are assets, and those assets have to be sold, and then the money has to be given to a third party.
Absolutely, and that makes it pretty tricky. Again, when it comes to property, and if it's been laundered, a fake trail is created, and therefore unraveling that trail must be the reason where some of these prosecution cases take so much time to prove, Vikas.
Time is taken because you must understand that I think viewers also should know that money laundering trial and the trial in the scheduled offence, they have to be tried in the court of law, and both of them have to be tried, and both are intertwined. If there is an acquittal or a discharge or a quashment of the FIR in the scheduled offence, the money laundering offence goes. This is the major problem which we are facing nowadays in our country, that the scheduled offence on the basis of which the money laundering starts, the case is initiated, that itself goes. If that goes, then nothing is sustainable. So most of the cases which we are filing is where the jurisdictional police is unable to prove the case in the scheduled offence. If they are unable to prove the case in scheduled offence, money laundering cannot sustain. So they are intertwined. So that is why it's going to take long, because there are multiple trials which have to happen. And in every money laundering case, there are empty number of accused. No money laundering case has less than 25, 30 accused. Sometimes there are 100 accused. So 100 accused means at least 30, 40, 50 lawyers. Those trials will never happen in our country. We have an example of Augusta Westland where ECIR was registered in 2014. We are now in 2024. 10 years have passed, even the charges have not been framed in this case. Forget about the trial. So how do you achieve acquittal or conviction when even the charges are not being framed? There are more than 50 accused in that case. In 10 years, the trial has not started. So we are not talking about distribution of property, but we have to make sure that the trials are concluded.
Very, very important, significant points that you make, Vikas. So I want to ask you, if you had the opportunity to write the law and amend the existing provisions to ensure that justice is served in its fullest sense, including even those accused who have a right to be heard properly and those who may be impacted, what would you suggest that could achieve the objectives, the very broad objective that the Prime Minister has outlined?
I think my major view would be that we have to give way to the predicate offence first. What is happening is that predicate offences have not even taken off, and Enforcement Directorate takes the charge. They arrest the accused at the first instance, they file the prosecution complaint at the first instance, they try to initiate the trial at the first instance. But the predicate offence trial is lagging behind. If we wait for a legitimate outcome in the predicate offence, then money laundering offence can be concluded in no period of time, because we already have an offence before us. We already have at least charges before us. But today there is an overlapping. Today enforcement directors has taken a charge and moved much ahead. They don't wait for the predicate offence to reach at least a particular stage. That is the framing of charge. Because of that, time gap, there is no conclusion in the trial. So I think there a little bit of amendment is required under Section 44 and 45 of the Money Laundering Act. There we must, at least the government and the parliament should apply its mind and say how to conclude the trials in the reasonable period of time. So we can only talk about distribution of assets when we see the outcome of the trial. If we don't even see framing of charges in 10 years, how do we see trial coming to an end? As you have noticed the statistics, the confiscated property till January 2023 is only 32 crores out of 115 crores, which is 0.03%. So confiscation comes when the trial is concluded. So I think as a criminal lawyer, I feel we can only achieve this if we are able to conclude the trial in a reasonable period of time. That can only happen when we wait for the predicate offence to kick off. We should wait for the outcome of the predicate offence, and then the money laundering should follow. Then the trial of the money laundering should follow.
Absolutely, and I'm also reminded of what the Prime Minister, citing an example when he was the Chief Minister in Gujarat, he cites this, and viewers, I'll relate this to you and you can always go and check the video out. He says, Prime Minister Modi says that in Bhavnagar when he was the Chief Minister, black jaggery was caught in large quantities because it is used for making illegal alcohol, and we know that Gujarat has prohibition. And this black jaggery, the molasses that were seized, was kept at the police station. It rained heavily that day, so mosquitoes and flies began to surface and people couldn't pass through that road. And the law says that it cannot be disposed of. We also see that with a lot of the vehicles that are seized, although there are some changes in the new CRPC Bharati Nyaya Sanhita that has happened, but this is just a small example of a Prime Minister who is pretty detail oriented also talking about this. But Vikas, as we conclude, you would have seen that debate where the government and Prime Minister Modi has also by his opponents been reminded repeatedly of that claim that there will be 15 lakh rupees in everyone's account, which was perhaps never said, but let's leave that debate aside. Do you think that with this assertion by the Prime Minister, that broad goal could be achieved, or do you think there will be a lot of legal heavy lifting changes that will be required, including much faster trials to ensure that ill-gotten wealth goes back to those who it has been forced out of and or is also used for public good?
Money laundering attracts a lot of confiscation of money, as the figures itself suggest, 1,25,000 crore. And let me tell you something very interesting. 1,25,000 crore worth of assets. I have seen all these provisional attachment orders. Majority of them are calculated on the basis of book value. If a property is purchased in 70s, 80s, 90s, what I have seen in the files is the value given in the sale deed, which may be very, very old. So today the value of a property which was purchased in 70s and 80s, imagine it is at least 10 times. So this figure of 1,25,000 crore is a conservative figure. It is much more. I hope I am making myself clear. I am just telling you what is it. The figure is much more.
Absolutely.
Because if you take the present market value of these properties, it will be 10 times. So it is not that. So therefore, the moment we are able to achieve disposal of trial, see the kind of money which will be at the disposal of the central government. If we calculate the market value of the property, it may be 10 lakh crore. Because I have very, very often seen the valuation given in the provisional attachment order is on the basis of book value of the sale deed.
But equally, while I agree with you that this is undervalued, but equally during auctions of seized assets under different laws, SURFACE auctions, or when it comes to bank default cases, the auction value is never near the market value. Would that also not apply in such matters?
No, so that I'm talking about 10 times. I know a house in GK1 which is confiscated by the government, which is purchased in 70s. The book value will be what, about 10 lakhs or 20 lakhs? Today it is almost 30 crores. So if that property is sold in the market, it may be sold say 10% less than the market value. Then also it is 28, 29 crores. What is shown in the provisional attachment order is only 10 to 20 lakhs.
Fair
So
point.
therefore, so the figure is much more. According to my, I deal with these cases on daily basis, and I have very often, when we discuss with the clients, they say that my 10 properties have been attached, but the proceeds of crime is only X amount of money. I can pay the proceeds of crime by selling only one property, but they have attached my 10 properties. Because the valuation is the book value.
Well, that's a very, very important point at the end of our conversation, Vikas, that you make, that the actual money is far higher if we try and value it at present market rates. And all the more important, perhaps, viewers, that what the Prime Minister is alluding to, those legal changes, both in terms of lawmaking and at the judicial level, happen, and because a lot of these assets get locked for years. Some of the numbers that we have shown you are very, very significant. The amount of confiscations is minuscule, and therefore in the interest of justice being served for everyone, the changes, procedural as well as legal, are very, very important to achieve the objective of ensuring that ill-gotten wealth is put to good use. Vikas Pahwa, thank you very much for taking out the time to explain in such painstaking detail what could be possible and what should be done to ensure that justice is served. Thank you very much for your time with us today. And viewers, with that, it's a wrap on this decoding of Prime Minister Modi's blockbuster interview to the India Today group. One aspect of that very extensive interview. I'll urge you once again to go and check out all the stories that have been done across the India Today universe, including businesstoday.in and on Business Today on YouTube and other platforms for the details of that interview. I'll see you again. Until then, goodbye.